Every day in the USA, people find themselves in court.
All right, let's go back to our memory lanes cases. Rebecca Randall is here. This is also a second hearing. Mr. Weiner is here on behalf of the defendant. McBauer is here. And Ms. Corpening, the manager, is here. Let me make my note. All right. We struggled a little bit last week. I think we determined that through March, rent was $14.50. I'm not sure what the status is here today. What's the status today, Mr. Weiner? Your mic's on mute.
Pardon me. It had been $1,475 in lot and home and late fee and a balance of a down payment. She was making those payments gradually. So that totaled $1,475 plus $257.10 in court fees, or a total of $1,732.10. Now, Your Honor, the reason why we adjourned this, if you recall, Ms. Randall had made a representation to the court. She had filed a complaint with the Department of Civil Rights after we had filed the eviction. And she had indicated that she was withdrawing that complaint. So we ended up calling the Department of Civil Rights, and the Department of Civil Rights indicated that Ms. Randall had contacted them, but she had not withdrawn the complaint. In fact, what she ended up doing was she contacted Ms. Sharpening, and she tried to negotiate a resolution using the Department of Civil Rights complaint as kind of a lever to negotiate. And we're not interested in that. We will defend the complaint that she has filed with the Department of Civil Rights. That's separate. That's going to go on. And we're looking for a judgment of $1,732.10. And as you know, she's going to owe rent of $975 on April 1st as well. But that's where we stand.
All right, Miss Randall, what's your position?
What's my position?
When we got to where we were last week, I thought you wanted to just pay the rent and move forward. And there, you certainly will be able to do that. What's your position?
I tried to work out a deal with them because I'm on Social Security. The only reason I'm behind is Social Security messed up on a payment because I'm still fighting to get my mailbox fixed here, Your Honor. Still to this day, I've been here since September. Still have my mailbox hasn't been fixed. I've put in complaint after complaint with the post office, missed a paperwork because they sent it to my mailing address and I can't even get in my mailbox. So I missed that, so it put me behind on a payment. I've never missed a payment. I think we
discussed that. That's a postal service issue rather than
exactly.
A park issue. Is that correct, Ms. Corpening?
Right, but yes, I'm behind on rent because of that reason, Your Honor. So, all right, like I told her, is if we can't figure out a deal, I'll pack up and move, but I'm going to need more than 10 days.
I was not aware of the request for more time and a judgment for possession. Chris, have you spoken to that issue with Ms. Randall?
When I spoke to her on Friday, she made mention that she needed to know what we were going to do, and I told her that we would handle that in court.
Okay. What would?
All right. I wish you would send me the judgments in advance. It would make my life easier, even if you sent me a blank one. But let's do this one.
Okay.
Rent
By the way,
through
Your Honor.
March is 1,475. Court costs are 257.10. And the total is 1,732.10. That's due within 10 days, Miss Randall, or you're subject to being evicted. Now, I used to include the upcoming month's rent in the judgment, but I got appealed on a case. And Judge Stutzman says I can't do that. So I'm bound by the local opinion. So I would have included 9/75 April in this judgment. I used to do it particularly when people were asking for emergency financial help. Anyway, it's only through the month of March. So if we add 9/75 to that, there may also be a late fee in there that I didn't calculate. Plus 1,732 is 2,707.10. That's how much you owe 2,000 through April, but you have to pay 1,732.10. If you can't pay within 10 days, they can have the sheriff put you out while your stuff's out on the curb, and that's not a very pleasant process. You heard me discuss with Mr. Nguyen, they have 56 days from today to ask for the writ of eviction and 56 days to serve it. So they don't have to evict you on the 10th day, but they can. And the only thing that cures it is paying the entire amount of the rent. Partial payment will not pay the, let's say you get some emergency financial help and they pay $1,000. You still owe 730.10, plus you would also owe April's rent. So do you have a plan to try to get caught up?
If I can't afford the 2,000, whatever it is, by myself, I'm on Social Security. I was trying to ask Chris Friday if she could give me until the 13th or the 15th, and I'd get out willingly with no problem.
Well, now there's another option. If you do agree to move, and they can agree to give you more time. 10 days from today would be
the
April
10th or 9th. 9th, 10th.
That's a Friday. 13th is a Monday.
If she could
So
give
if
me
you
until
agree to simply
that following
vacate,
Monday, I would get out willingly.
all right. If you do leave, you need to turn in your keys and give your forwarding address in writing within 4 days of your leaving.
Okay.
As a practical matter, no writ would enter until April 13th anyway. Friday is the 10th.
If she's willing to give me on her until Monday the 13th, we will be gone.
All right, that may solve this. Now, you may still owe money. They may have a subsequent hearing regarding money damages. That'll be a different hearing where people will be placed under oath. We'll determine how much the rent is. Is there a security deposit? Should rent be abated because the heat didn't work or the water heater went out or something? We'll discuss that. But this judgment is called a possession judgment. It's not a money judgment. They are asking you to move. So, all right. If you do vacate, again, you need to turn in your keys and give your forwarding address within 4 days of your moving. If we're going to have a money hearing, it'll be at a later time. You understand?
Okay. Yes, sir. Chris, are you willing to give me until the 13th?
I would have to check the calendar and speak with Richard on that.
Well, I will, because I won't even be here to sign it, but Judge Pattis would have to sign it. So even if it came
Let's
in on
just do the 13th.
they wouldn't have
13th
signed
is
it.
okay.
We'll do the 13th, Your Honor.
13th.
Thank you, guys. I will be out. I will bring my keys and everything to you guys.
Very good. All right.
Thank you, Your Honor.
We got
Have a
one
nice day.
more, two more. and then this one. This is entitled John Beachy versus Megan Sudbury. Ms. Sudbury is here with me. And Mr. Beachy is here by. Mr. Beachy, are you also Mile 1?
And I am Juan Herrera.
All right. All right, which case are you here on?
Is with me, Junior.
Yes.
It's about the land or ask for the payment or leave the property in
Yeah, who's
Sturgis,
your
Michigan.
tenant?
Who's your tenant? Let me face. Memorial Lands.
What's your tenant's name?
Let me find honor.
Judge, it sounds like the plaintiff is Memory Lanes.
Yeah. It's 2 months. Tenant copy, Lord.
Are you Mauricio?
I am, sir. I am, Your Honor.
Well, you're about a half hour late for your hearing,
Apologize. It's
so
about,
that doesn't help. All right, you stay put for a minute.
of course, Your Honor.
You were here last time. We already had the hearing and you weren't here. You owe $3,697.25. That hearing was at 1:40. It's now 2:30, 2:25. We actually were late doing it. Anyway, I'm going to send you a copy of this default judgment. You or the restaurant or somebody needs to pay this rent, or you're subject to being evicted. So you're going to have to move to default aside, but I've ordered that you pay $3,335 plus court costs of $2,025 for a total of $3,697.25 by April 10th, or you're subject to being So if I were you, I would advise perhaps you go talk to Ms. Corpening and see what the deal is. All right, anyway, you're about 40 minutes late for your hearing, and we already did it. The other parties have all left. All right, anyway, I'll send you that in the mail. I suggest go talk to your manager.
Okay.
Thank you. We had an interpreter here for him last time, and we didn't. All right, let's return to file number 26311 LT, titled John Beachy versus Megan Sudbury. This is a property on South Thompson Lane. The parties are also in the midst of a misdemeanor case, but this is a termination of tenancy case. Ms. Sudbury is no longer there. It appears there may be some lockout law issues that we aren't here about, but we were trying, at least I was trying to get some closure to this. Ms. Sudbury wanted the remainder of her property back, and Mr. Beachy had one view of it, she had another. So let me start with you, Ms. Sudbury. Were you able to get your things?
Most of them, but not all of them. He had his sister-in-law contact me a couple days ago stating that some things, he wanted to return some things that he still had. I did not meet up with her because I don't feel like I can meet with anybody he's affiliated with without a witness. Also, he had said previously in court, didn't have any of my belongings anymore. So when I was given the key to the storage and removed my things, I actually put another lock on that storage unit that day because I didn't trust that my stuff wouldn't be messed with. They did in fact have another key to the storage unit because I had returned, I believe Friday, and their padlock was gone. So he or somebody does still have some things. I do have a list of things that are missing, but I also understand that if those aren't returned, then they will have to be dealt with in small claims court, which I am willing to pursue.
Meg, there is a specific statute that allows a summary proceeding judge to deal with personal property. In the Corey Lake case, the Rosemary Blair case, Judge Stutzman ruled that I was incorrect in dealing with personal property. And Daniel Hatch then later cited the statute. At any rate, I'm not going to feel compelled to be bound by that ruling, but that's a separate issue than possession. Ms. Sudbury, do you have any objection to Mr. Beachy having immediate possession of the premises on Thompson Lane?
No. Does an eviction stay on my record since I'm technically not being evicted? I haven't been there in a couple months, and he forced me out.
Yes, it will.
Okay.
Mr. Beachy, are you willing to dismiss this case in light of the fact that she is vacated?
At this time, Your Honor, I don't think I'm willing to do that.
All right. Then, Ms. Sudbury, I would encourage you to file a lawsuit under the landlord-tenant lockout law where you're entitled to recover 3 times treble damages for any loss that you suffered. I don't know who's right or wrong here, but if it was dismissed, that would be the end of it. I'm going to enter an order for immediate possession. It will show up on your record as a eviction. Although he didn't do it right, you can't just take somebody's stuff and all lock it in a building, even though it seems like a logical thing to do in a case like this. You do have a right to sue him under the lockout statute and any other damage you've suffered. But for possession, you see what I mean? I'm going to just show a consent. I'll give you 10 days to appeal this, which is 4/10/25. Defendant has vacated. Plaintiff may have immediate possession.
Your Honor, can I make a statement?
Yes?
The one that removed her belongings from my house.
Yes? Go say that again.
I'm not the one that removed her belongings from my house.
Well, you allowed it to happen. You're her landlord. So
I know.
let's say I'm the landlord and I let some third party come in and take all my tenant stuff out and put it somewhere. I could still have liability for that.
Your Honor, I didn't allow it or allow it because I wasn't there when it happened.
All right, well, that I guess will be determined. At any rate, you can have immediate possession of your property. She's vacated. I think you probably changed the locks. If you didn't, I would recommend that you do that. She's moved on. Normally, I would require her to give a forwarding address in writing, but I'm not gonna do that. This is a very unfortunate situation all around, but we've gotten to the point where you're out, you got most of your property back. You've got possession of your home back. Because of the no contact provision, there was a period where he was out of his house or you were in his house with his kids. Very awkward circumstance. But you may have immediate possession if you wish to file an action either in general civil court for up to $25,000 or in small claims court for $7,000. You may do that. I'll send you out to the counter and you can get a copy of this order showing that you have vacated, and Mr. Beachy will send you one in the mail. You got your property back. If there's further issues to be resolved, we'll do it in a small claims case. Do you have any questions?
No, sir.
Mr. Beachy, do you have any?
Yes, Your Honor. Go ahead. Listen up. My wallet.
Say that again.
I still don't have a key or my wallet. It's Sudbury. I was arrested.
Yeah, there's that whole issue. You contend that she took your wallet and your credit cards and all that. Same thing. She denied that she did it. So if you want to sue her or counter sue her, you can do that. It certainly is a nuisance to lose your wallet. I have possession jurisdiction, but not that. That's an allegation of actually a theft. Intention was she was the only one that would have opportunity to do it. Her position is I didn't have anything to do with it, but neither party was under oath. If you want to recover that, you may have to sue her separately in another action.
Your Honor,
All right.
Your Honor,
Yes.
she was in possession of my car key the night the police were called.
Say
And
that again.
it's in full possession of that car key the night the police were called and I was arrested.
Your sound keeps breaking up. Meg,
Megan,
could you hear that?
Megan Sudbury.
No, sir.
Yeah, you're in a car somewhere, which is not ideal. This was an expensive car, Mercedes or something, as I recall.
BMW.
But I can't hear you.
It was a BMW, Your Honor, and she had full
BMW.
possession of that key the night that I was arrested.
Yes. Same thing. I don't know what it is or what happened to it. This is about the tenancy. If you want to sue her for your replacement key or your wallet, you can do that in a separate action. But I'm not going to build a ship in a bottle and resolve this difficult circumstance. I got premises back. She's out. She has a now eviction on her record. She may sue you, may sue her. We'll hear more about it. I would suggest everybody just move on. That would be too simple. Ms. Sudbury, if you go out to the counter, get a copy of this order and you're free. Mr. Beachy, so are you. Good luck, sir.
Thank you, Your Honor.
You locked my things inside a building and you took my BMW key. Mauricio is 40 minutes late, so now he owes the default fee. The mailbox has been broken since September, so the rent is overdue. You have an eviction on your record and I still can't find my wallet.